Hi friends from around the world. This is about licensing of trademarks and designs. We didn't talk much about licensing so far, but licensing is very current. Contractual conditions between licensor and licensee, and there are many constructions about licenses which can be exclusive, non-exclusive, limited in the time, limited to a territory, limited to some products or some goods with regard to the license, or maybe limited in what other fashion. So what my point here is, there's contractual liberty in Europe. Whatever the licensee and the licensor may agree to, that should be okay, unless there is some competition law involved, which I will not go into here. So what we have, licensee and licensor. But what are the rights of the licensee with regard to the licensor? That's what I want to do here. But, well, not rather with regard to licensor, with regard to infringement. That is our thematic today, subject matter. What we want to know, whether the licensee can make infringement claims with regard to infringers or potential infringers in Europe, and this about trademarks and designs. You know, often trademarks and designs, so it's called sometimes design patent right, but it is rather a trademark right, rather comparable to trademark than to patents. So therefore I put them here together. And this is about two cases from the European Court of Justice, which, as more often than not, it is being seized by referral questions from national courts. In this case, two courts come from Germany. The two cases come from Germany. The first case is about design rights, right? There is a licensee for laundry balls from a Switzerland company who's the holder of the design. And this licensee wanted to sue an infringer also in Germany. And it went to the Düsseldorf court, which is the design court, the European design court, and the community design court, and it went higher, and it comes to the referral court, which had doubt about the European the community design regulation, and here about 33 and 32 of the CDR. Okay. The first question, there were two questions which have been asked. So the first question was whether the licensee was able to bring an action for infringement against the infringer without having registered its license into the EU IPO register. So that is what Article 33 of the CDR is about. Here on the screen, it requires in 33.2, it requires that the license is being registered at the EU IPO for taking actions against third parties. Legal act shall have only effect vis-à-vis a third party in all member states after entry into the register. That is the wording of Article 33.2. Now that seems to suggest that the registry is a precondition for suing in court, for being active legitimation to be in court suing against an infringer. And the situation in the member states is not clear either. So there, in Germany, for example, you don't need to have something registered, a license registered, wherever, in order to sue in court. Just from the moment you sign the license, that is already okay. Whereas in Spain, the situation is different. Only after entering into the registry of the Spanish design or patent office is a licensee have the power to sue in court. So it was brought to the Court of Justice, and it says, well, literally it seems to suggest that you need to register into the EU IPO register in order to go to court, but in fact you have to make a teleological interpretation, so from the context, and the context says that is a kind of object of asset, where it is placed in the Article 33. So it is more than the prescription, the rule. The Article 33 responds to good faith in order to protect the good faith of acquirer of some asset, meaning that if the licensee is not registered in the EU IPO register, the acquirer of that trademark, for example, it can rely on that there is no license being granted to somebody else. It is a bit against the wording of the rule of the Article 33, but it is a purpose-oriented interpretation, I would say, which favors what is to be, the infringement proceedings, the holder of licensees, in order to pursue infringement proceedings and not being hindered by any formality requirement beforehand. The second question concerns Article 32, now also here on the screen, and it is about to know whether the licensee can pursue its own damage, not the damage of the RCD holder, but its own damage when it is pursuing in court on its own name. Or, on the contrary, as the Article 32(4) suggests, must he be confined to the intervener with regard to the main proceedings held by the RCD owner. And again, a purpose-oriented interpretation from the Court of Justice here. It is rather that the licensee can on its own pursue the infringement of its of the RCD and pursue its own damage claim against the infringer. So that is quite good news, I would say, for those RCD holders and the licensees. They can go with their own way, always with the consent of the RCD holder. This consent can be given already in the contract, in the licensee contract. So this is RCD 2016. We have in the same 2016 also a ruling on trademarks. Astonishing enough, same year for the two. And we had again a licensee in Germany, and that was a licensee for bedding and bed sheets and so on, and feathers and, well, this kind of thing. And it was a trademark Arctis. Briding was the licensee, and it had, the license in order to market this in Germany. And there was Mr. Hassan, an individual who had also used the trademark Arctis for these kind of goods and was sued for infringement by Briding the licensee. And there is Article 27 here involved in the European Trademark Regulation, which is here on the screen, and you can see it is practically more or less the same what has been so to say defined with regard to trademark to designs, the community designs, which we have seen beforehand, the Article 33. So not very much astonishing. The court here says, well, it is the purpose which counts, the overall context which counts, and it doesn't make sense to make a condition of the registry in order to pursue licensee claims against the infringer. It is about the infringement. It is not about the registry. So it can be clearly brought to the attention of the court that there is a license agreement without looking into the register. It may be that the register is pending or whatever. So, and again, it is object-oriented and teleologically founded in the sense that, well, Article 27 is the object-related, and its purpose is to protect against or for the good faith of the acquirer of the subject matter of the asset, which is the trademark. So again, here a purpose-oriented. Now, in general, it is quite easy and quite straightforward, but it is still of a certain importance because it is against the wording, so to say, of the European Trademark Regulation and the Community Design Regulation. Now, would you pass on the registry of the design of the trademark? Well, probably not. It is very cheap, so there is a payment for doing so. It's a recordal, but it is cheap and it is straightforward. It can be done within, it's a formality in order to be registered. It's quick, and you have, so to say, a kind of protection against any acquirer of the trademark or of the design, so that he knows that there is a licensee in your favor and your licensee will be, so to say, protected against him. But meanwhile, you don't be in the register, you are not precluded from pursuing infringement claims in its own name. Now, in the contract of the license contract between licensor and licensee, it should be indicated that you pursue your own, or said that the licensee is in agreement that you pursue the actions in court with regard to your territory or whatever. So this consent must not be asked beforehand before you go to court. So you should have it already incorporated in your license agreement. So is that interesting for you? Are you in the license market of your client?